the confirmation or non-confirmation of charges, of accusations against you. No evidence will be adduced today or will be presented, and the individual responsibility of Mr. Said will not be discussed. Pursuant to Article 60, first paragraph of the Rome Statute of the International Criminal Court and of Rule 121 of the Rules of Procedures and Evidence, the scope of this hearing today is limited to allowing the single judge to be satisfied that the person subject to a warrant of arrest is informed of the crimes he is alleged to have committed, that this person is informed of his rights under the Rome Statutes, and the date on which the Chamber intends to hold the hearing to confirm or decline to confirm the charges will be announced later. Mr. Said, have you been informed of the crimes you are alleged to have committed?
Answer: yes, that is correct. I have been provided with the necessary documents and I have read them.
Thank you very much. The registry has indeed informed the Chamber that Mr. Said has been served with a version of the warrant of arrest dated 31st January 2019, containing only minimal redactions. Now, I would like to clarify that the warrant of arrest issued for Mr. Said on 7th January 2019 is still under seal and is not yet available to the public, not even in redacted form. The reason for this is that a request from the Office of the Prosecutor to apply reductions to the warrant is pending and will be decided by the Chamber in due course. The Chamber considers the publicity of criminal proceedings a cornerstone of fair trial, and restrictions to this principle can be justified only by the proven need to preserve other interests provided for by the statute, and first and foremost, the security of witnesses and victims in accordance with Article 68, first paragraph. In any case, for the purpose of these proceedings, the Chamber is fully satisfied that Mr. Said has been informed as necessary of the crimes he is alleged to have committed on the basis of the warrant of arrest. Now, Madam Court Officer, I would kindly ask you to read out the charges in the format and content allowed by the publicity restrictions I've just discussed earlier.
Thank you, Your Honor. On 7 January 2019, Pre-Trial Chamber 2 concluded that there were reasonable grounds to believe that Mr. Mahamat Said Addel, a national of the Central African Republic, born on 25 February 1970 in Bria, Ndele Province, is criminally responsible pursuant to Articles 25(3)(a), b, c, and d, and 28(a) of the Statute for the Crimes Against Humanity. of A. Imprisonment or other severe deprivation of liberty, Article 7(1)(e) of the statute. B. Torture, Article 7(1)(f) of the statute. C. Persecution, Article 7(1)(h) of the statute. D. Enforced disappearance, Article 7(1)(i) of the statute. E. And other inhuman acts, Article 7(1)(k) of the statute, as well as for the war crimes of F. Torture, Article 8(2)(c)(i) of the statute, and G. Cruel treatment, Article 8(2)(c)(i) of the statute, all committed in the Central African Republic in 2013 as set forth and detailed in the warrant of arrest.
Thank you very much, Madam Court Officer. Mr. Said, now we will dwell upon your rights. Have you been informed of the rights which are accorded to you as a suspect under the Rome Statute of the International Criminal Court?
A droit mbi a de ti fani ne mbi pepe. Et puis mbi inga ke mbi ki
Answer. I am not yet very fully informed of my rights. I am aware that as a suspect, I am presumed innocent.
mbi ko kuna lango ti mangani.
That is pending any trial.
And the main rights you are accorded with by the Rome Statute. You have the right to be informed promptly and in detail of the nature, the cause, and content of the charges in a language that you fully understand and speak. Would you please, Mr. Said, indicate which language or languages you fully understand and speak?
Sangola mbi ki tene ni nzoni.
Answer. I speak Sango very well.
You have also to have free of cost the assistance of a competent interpreter and such translations as are necessary to meet the requirements of fairness. You have the right to be allowed adequate time and facilities for the preparation of your defense and the right to communicate freely with your counsel of your choosing. You have the right to remain silent and not to be compelled to testify against yourself or to confess guilt. You have the right to make an unsworn oral or written statement in your defense in due course, not today. You have the right to receive as soon as possible material showing or tending to show your innocence or mitigating your guilt or affecting the credibility of incriminating evidence. At the confirmation of charges hearing, you will have the right to object to the charges, to challenge the evidence presented by the prosecutor, and to present evidence yourself. If the charges are not confirmed, there will not be a trial in this case, and the proceedings would be terminated. Finally, you have the right to apply for interim release pending trial. Have you heard and understood well, Mr. Said, what I've just said?
Ouais, mbima adroa sosimo asayan na mbikweso.
Answer, yes, indeed. I have fully understood all the rights that you have enumerated to me.
Thank you very much, Mr. Said. Now I will set the date for the confirmation of charges hearing. We have considered all relevant factors, including the need for the parties and the participants to prepare the rights of Mr. Said, especially his right to be tried without undue delay, as well as the current exceptional circumstances due to the COVID-19 pandemic. Therefore, the date for the commencement of the confirmation of charges hearing is set for Tuesday, 5th October 2021. Depending on the development of the proceedings, this date may be changed as provided for in Rule 121, paragraph 7 of the Rules of Procedure and Evidence, upon request of either the prosecutor or the defense, or by the pretrial chamber on its own motion. Before concluding the hearing, I inform the parties of the following steps in these proceedings. First, it is recalled that pursuant to Rule 121, Paragraph 2, letter B of the Rules of Procedure and Evidence, status conferences shall be held to ensure that disclosure takes place in a transparent, efficient, and expeditious manner. Such status conferences may be scheduled by the single judge by his own initiative, proprio motu, but also upon request of the parties. Second, I would like to inform the parties that in due course a set of decisions will be issued by the Chamber to ensure that the proceedings are conducted properly and expeditiously, namely decisions on the modalities and procedure for evidence disclosure, decision on the calendar for the disclosure of evidence to ensure organized and smooth disclosure between the parties, with communication of disclosed evidence to the Chamber, a decision on principles for reductions, and a decisions on victims' participation. Third, with a view to ensuring that disclosure commences as soon as possible and takes place under satisfactory conditions, I instruct the prosecutor to file observations on the modalities and procedure for evidence disclosure by no later than 5 February 2021. Now, I would kindly ask the parties if there are any additional points they would like to raise that were discussed today. I start with you, Madam Prosecutor.
No, Mr. President. We don't have any further observations to make.
Thank you very much, Madam Prosecutor. Mr. Counsel for Mr. Said, do you have any point you wish to raise?
Je vous remercie.
Mr. Maduku, thank you very much, Mr. President. Gentlemen and ladies of the court, thank you. I would like to reiterate the fact that my client and myself fully respect your court. Given my contacts with Mr. Said, he has reassured me of his full cooperation with the International Criminal Court. He is fully prepared to cooperate with the court, so he will be available to be tried if necessary. However, we would like in the defense to request that the Office of the Prosecutor should disclose to us all the materials related to this case. It is true that my client is in The Hague and I am based in Bangui, so there are difficulties at that level, but we really need to have all the materials available to us in good time so that we can properly prepare the defense. What is clear is that as at this date, my client is presumed to be innocent. And if we have possession of all the evidentiary materials, we will arrange for our own witnesses, certain of the witnesses, to testify for the defense. I am aware that this is only the beginning of the procedure. We have followed up all the charges laid out by the prosecutor, and we are prepared to defend my client against those charges. Mr. Said is prepared himself. And as I have said, the procedure is only beginning, but the truth will out, and I can say clearly that that truth will come out in favor of Mr. Said based on everything that we have at our disposal. Thank you very much, Mr. President.
Thank you, Mr. Counsel. Your points are noted. I can reassure you, as I mentioned earlier, that the court is fully committed to ensuring an expeditious conduct of the proceedings. It is indeed the duty and the commitment of the Office of the Prosecutor and of the Chamber under the Rome Statute to ensure that disclosure and any other requirements are met in due course and expeditiously. Thank you for your intervention. Mr. Said, are there any points you would like to raise before I declare the end of this hearing?
Bikina tena quoi pas? Bikina tena pas? Biki réservé.
Mr. Said, I have nothing to add. I will be silent for now, and I will express myself when the time comes.
Thank you very much. We have therefore come to the end of the hearing on the initial appearance of Mr. Mahamat Said Addel Kani. I wish to thank the parties, our interpreters, our field office in Bangui, the courtroom staff, and also the technical staff for sorting out the problems, the technical problems we have encountered yesterday. The hearing is now closed, and I wish everyone a good afternoon.
All rise.